A group of landowners sued, and this case has made its way up to the North Carolina Supreme Court. We recently had a ruling. Tell us what the court said.
The issue, by the time it reached the Supreme Court, was pretty clear-cut. The question before the court was, do these land use moratoria that the Department of Transportation imposes, are those police power regulations, which are imposed to protect public safety and health, and those kind of regulations don't require compensation? Or is this, in fact, an exercise of the state's power of eminent domain, which does require compensation? That was the issue, and the Supreme Court said it's the latter. This is an exercise of the eminent domain power, and all those landowners who've been suffering under the weight of these regulations for decades in some cases are now going to get compensated.
Let's talk a little bit about what it means, those two words, eminent domain. Why did the court seize on that and say that's what it is? What was DOT doing that the court has ruled is eminent domain power?
Well, unfortunately for the DOT, the General Assembly gave the game away when they actually passed the original legislation, because they said in their description of the bill that it was an act to control the cost of acquiring land for highway rights-of-way. And that's exactly what it did. There was no question here of protecting the public from some kind of health or safety problem. Building a carport or subdividing your land isn't going to expose anybody to a risk or danger. The only reason they were doing this was to prevent that land from increasing in value and make it cheaper to acquire when and if they finally decide to do so.